Welcome to the Probate Nation. My name is Richard Ruddy and I am the host of the program tonight. Probate is a process to transfer the title or ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. As we learned in an earlier program on fiduciary litigation, getting started on your probate journey can sometimes prove to be a challenge when you seek to admit a will to probate and get qualified. Or once you get qualified, you may encounter objections to the will admitted to probate or to a host of other matters. Our program today takes a much closer look at just what is a will, how do you get it admitted to probate, and what can be done when making a will to make it more likely to be admitted to probate over any objections that may be raised. Helping us today are two local attorneys experienced with the challenges that can arise with a document offered for probate and the fiduciary litigation that can ensue when there is a disagreement on whether that document is truly the last will and testament of the loved one who has passed away. Joining us today is Tom Ripczynski, an estate and trust litigator with the Tyson's Corner office of Offit Kerman Law Firm. He is also the current chairman of the South Fairfax Chamber of Commerce, president-elect of the Fairfax Bar Association, and past president of the Northern Virginia Bankruptcy Bar Association. Also joining us is Joseph Stewart, who has practiced law in Northern Virginia since 1993. He concentrates his practice on contested or complex estate, trust, and elder law cases, adult guardianships, estate and trust administration, and estate planning. Please welcome Tom Ripczynski and Joe Stewart. Fellas, welcome, and thank you for joining us today.
Pleasure.
Well, you know, we talk about getting a will admitted to probate, but there are these things that are called will substitutes, you know, things that don't go through probate. Tom, talk a little bit about some of those.
Well, there's a lot of different ways, a number of different ways to transfer property upon death, not necessarily through the use of a will, whether it's through life insurance or a trust document, for instance. Those are a couple of the examples that you don't have to necessarily have your will go through the standard probate process that we think of. You might use a list of assets as part of a will, but that's not something you could simply write down and say, I want so-and-so to get my stuff upon my death. But and nowadays you can also do a transfer on death deed where you can actually transfer real property without actually having to have it go through the standard probate process as well.
There are a number of things, but these are all what we call will substitutes. You know, in a prior show on fiduciary litigation, we discussed the importance of capacity, that you need to have capacity in order to execute a will, a certain type of capacity. And if you had that capacity, you also had to have the intent to make a will. Can you guys talk about that a little bit for our viewers?
I'll try the capacity part if you want to try the intent part, but really it's a very low threshold that a lot of people don't recognize. We think of oftentimes with our loved ones what it might take to understand a contract, for instance, before we sign off on a document, and someone might look at it and say, well, there's no way he understood what that contract was about. But when it comes to making a will and deciding who's going to receive one's belongings upon their death, the assets that they hold, it's more a sense of, do they know and understand what they're doing? Do they have the capacity to understand what it means to transfer assets upon their death? Do they have the capacity to know and understand what their assets are? If I'm leaving something to my loved ones, there has to be at least an appreciation, ability to understand that that's what it is that I'm leaving to a particular person, and that when they sign off on that document, that it's accomplishing that task. So it's a pretty low threshold.
And the intent part, Joseph, is a sort of separate...
Well, just when you do a document, you write it out, that it's apparent on the face of the document that you're intending to just apply after you die. That's testamentary intent.
So not a present interest skip of any kind. It's not.
No, you're not giving away anything. It only becomes effective only when you die, and it has to be apparent from reading the document that that was the intent, that not now, but when I die.
Okay, so there are some very specific statutory requirements that have to be met in order to actually make a valid will. So, Joe, can you review what those requirements are for us?
Sure. For a will, it has to be in writing. There are a couple of very small exceptions, but it has to be in writing and signed by the person who's making the will. If it's a typed up will or a printed will, and when it's signed by the person making it, called a testator, there has to be at least two other persons there present with the testator witnessing the signature and then also signing. It's possible that the testator can merely, if they're too weak to sign, they can acknowledge the document, and that's sufficient. And the other way to do it is to a written will, but all in the handwriting of the person who's making the will. It's called a holographic will, but
Okay.
it has to be entirely in their own handwriting.
Okay. Now, Tom, nobody does things perfectly. Do these things have to all be done perfectly in order for them to be effective?
For a long, long time, at least in Virginia, and by long I mean for hundreds of years, the answer to that was yes. But in the last 7 years or so, we had a new statute passed, which is consistent with the modern trend of what we call substantial compliance. And that is, because I am sure that if people out there don't know who haven't been through it themselves, they probably know someone who has had a will drawn up that for whatever reason didn't satisfy what I refer to as all the whistles and bells of a written will. And it's under those circumstances where in the past that will was then treated as if it didn't exist at all. It was discarded, and the person was treated as either intestate, or arguably if there was a prior will that might come into play, that would be a factor. But substantial compliance, or what I refer to as a de facto will, a will which in the past wouldn't have been considered a will, now can be.
Okay. So, we now move into pick up on that discussion about the different forms of a will. So, Tom, I'm going to continue with you. Joseph mentioned that not everything has to be written. So can we have an oral will?
Depends on who the we is in your
There you go.
Very limited, as Joe mentioned, very limited circumstance. Was actually a statutory carve-out for active military and seamen at sea, which effectively says that although we've put in place these strict requirements on a written will, those individuals who I just named, that small category, in those circumstances, the common law still applies. So as they were able to do a will before, one of those options formerly was oral wills, and so Virginia saw fit to carve that out, and so it's effectively saying that although we have all these other things in place, we're going to let those continue to exist. But that's it as far as I know, and Joe and I talked about it briefly, and we haven't come up with any other exceptions that we're aware of for an oral will.
Now, Joe, you mentioned the holographic will.
Right.
That's the handwritten will, typically in the handwriting of the person the testator. So how do we emit that handwritten will to probate?
Well, you have the will itself signed by the person who made it in their own handwriting, but you also need evidence that it was actually written in the handwriting of the person who died. Of course, the question doesn't come up until the person who made it has died. So typically you'll have an affidavit or what's called a deposition by someone who's familiar with the handwriting of the testator, the person who died, who can attest to their handwriting.
Okay.
That's sufficient to get it in.
Okay. And how about the type will? Tom, anybody can make a type will. They type it up, but talk about the special formalities we actually go through.
Right. Well, the typed will, of course, is the one that I guess most of us are accustomed to dealing with, where someone has gone to a lawyer, has gone to a professional, or not necessarily. They may have decided to type it up themselves, as opposed to writing it fully in their own hand. But here we need to have two witnesses witness the signing. The witnesses must be in each other's presence, and they must be together in the presence of the person signing that will. And what, again, in the most formalistic of them, so that we have what's called a self-proving version of that document, all of these necessary elements are then, in fact, recited in the will where they sign, that they see and observe the testator actually sign off on that will, and that they knew and understood that person to be of sound mind, and that this was in fact their intent. So that we have that testimony intent that we talked about. And then most typically, we'll also see these signatures notarized, so for it to be self-proving, you don't have to go find the individual and have them say, yeah, that's my signature, because you've got somebody who was there as an officer of the court to verify the signatures themselves, and then the testator has to actually do the signing, or as Joe pointed out, have someone at their direction or acknowledgement put an X or some other indication there for them.
Sure. And that, of course, is the most common and probably the most efficient way in which to get your will admitted to probate later on, is to do that, all those formalities.
Sure. It's that self-proving aspect of it that we would love to see all the clients who walk in who have some issue come up later. It sure would have been nice if they had all those whistles and bells in place.
So what if we have someone who has a typed up will and then decides to start making, they do all the formalities, and then they decide to 6 or 12 months later decide that they want to make an adjustment in some paragraph. Can they go in and just mark that off and initial that? Is that still good?
Joe, you want that one?
Well, maybe or maybe not, but it's about the worst thing to do, because when you start changing it becomes very questionable about whether that would take effect. And that relates back to the old rules, and cases over the years have been decided on that. So it would be a coin flip to know whether any of those changes would actually...
So it would be ill-advised for folks to take it upon themselves to change their will by starting to handwrite in their changes, which we see from time. Yes, Tom?
My own experience has been that when that happens, that's where we find ourselves in that substantial compliance situation, rather than being able to just say, see, we satisfied all the requirements, so this will should stand on its own. And when you involve me, when you involve the argument about whether or not it's substantially complied, you have to deal with more costs involved, more time usually, and as Joe said, it's not 100% given.
Sure. So we sign our will, we have a will that we think is our will, but I changed my mind. How do I revoke my will, Joe?
Well, simply by tearing it up. That's the simplest way to do it. Another way to do it is to do a subsequent will that revokes the earlier one, or you can do it in a baby will, so to speak, what's called a codicil, which is a change to a will which can revoke the will that you did earlier. So those are the typical ways of... So tearing it up, destroying it, burning, there's any way you can think of to destroy a document will suffice.
Okay. All right, so we have a will. Someone has passed away. We want to admit it to probate. And so we've talked a little bit about the simplest way is you have that self-proving affidavit attached to the will. You go up to the probate office with that, or you have a holographic will, and you go up to the probate office with that and the appropriate depositions. And the probate office admits it ex parte, and off you go. And that generally is the most efficient. And I would tell our viewers that a lot of that is discussed on the Probate Nation website as we look at each of the jurisdictions and how they make those appointments and have you come in to do that ex parte admission. Some folks actually will initiate a legal proceeding called, to admit the will to probate, called an ex parte process through the court. Talk a little bit about that, Tom. What are you doing there? And why do you do that?
Well, the ex parte process, and please have your listeners forgive all the Latin that ends up getting thrown around, essentially just means you're in there without anybody else in the family, anybody else who might have an interest in these ex parte proceedings. And that is because you may not be 100% certain that this is in fact the person's last will and testament, or it may be that you're certain that it's the last will, but that someone else has already raised issues that they were aware of something else, or in addition, they may have said, it doesn't matter what it says, I'm going to contest these things. So you go in and you ask really for the court to just sort of put their blessing on it. That's the ex parte nature is, there's nothing really different, out of the ordinary, no reason to think that the document we have in our hands shouldn't be approved, but there's something about what you know, the dynamic of the family, the circumstances, to just want the court to sign off on it.
What's the normal timeline? I mean, you file your petition. Well, what actually is the nature of the pleading you actually file with the court in order to start that process?
Well, when it's the ex parte with the court and not an an inter-party or a quasi-inter-party, which are sort of variations on the theme, you just file a complaint. The complaint lays out the basic facts of the will as you know them, the fact that you've satisfied in your mind either all of the reasons that it should be upheld under the statute, or if there's some quirkiness to it, you explain it, but if you have no awareness that there's anyone else out there, you're really just explaining it to the court. And the reason there's any delay at all, one is just be able to get on the court's docket. That may take a week or two to get on the docket. But also because, at least in my experience, it has been that anyone who you believe may have an interest, it makes sense to at least give them notice of the proceeding. Not formally serve them, but giving them notice. So to give them enough notice, I've seen and talked with other practitioners, generally giving them at least the standard, what we use for a normal complaint when it has to be served, is 21 days. So it can be done quicker than that, but it's typical that we would give them several weeks. But then you're there, the court signs off on it, and you've got an order that can be relied upon.
That's excellent. Now, the last way, of course, to get a will admitted to probate is where there's a dispute, and we end up actually with the classic will contest. So talk a little bit about that. What are some of the reasons that arises, and how does that unfold for people?
Well, it arises because you have someone, a family member, or someone who would receive the estate of the person who died. If they had no will, they have questions about the will, and they raise questions. And that comes up in a couple of different ways, but in essence, within a year overall, you have to challenge the probate of a will. Now you can do, there's a couple of different ways to do it in Virginia, slight technical differences there, but in essence, within a year of the time the will is originally accepted for probate.
Okay.
It can also come up if you have if the person who is offering the will decides to have a full-blown hearing up front, the same issues arise to see whether this is the last will of the person who died.
Talk a little bit about some of the techniques that there's, in order to avoid will challenges. Is there anything particularly people can do in their documents?
Well, the first is doing it right in the first place. And if there's any question about whether Grandpa understand what the will says, then you oftentimes, some attorneys will have videotape it. And sometimes they'll have an assessment done by a physician ahead of time to ensure that, to certify the person can make understand what's happening. Another way to do is building in the document itself what's called an in terrorem clause, which literally means to strike terror in the hearts of people who would challenge the will, okay? In Virginia, that does work, but in a very strictly limited way. So it depends upon what the clause says. Typically it says anyone who challenges this will get nothing. And it works for anyone who actually would be a beneficiary under the will, but it's ineffective for those who are cut out of the will. It doesn't do anything because they lose nothing by challenging the will.
Of course.
So it's a limited use, but it can be helpful.
Tom, talk just real briefly, will contests, and what kind of time frame are we looking at in order to get things to trial, and what kind of cost, do we look at, when people try to challenge these things?
Unfortunately, they're really as varied as there are circumstances out there in each family or each will. But at a minimum, you're committed to having to go through this initial process that I described of getting the complaint filed, getting it served with an answer out there. So you're already weeks into the process. But typically, once that contest is there, once you've formalized somebody raising the issue, we're fortunate here, at least in Northern Virginia with our jurisdictions, to be able to get to trial, to have these things resolved on a very timely basis, and that typically means within a year. But we're not talking within weeks. We're hoping to make sure that we can be within that year. And I would say, depending on the nature of the dispute, depending on how well the attorneys work together, oftentimes you could sort of focus on a narrow issue and maybe get to trial quicker. But under those circumstances, I think you're probably still looking at 6-7 months, even if you could stipulate to all the relevant facts and really just focus on the core legal issue. And so you do what you can to as Joe pointed out, narrow the disputes in the drafting process, but then you can do certain things in the litigation process too, using these ex parte or inter parte things. We give them notice, put them on notice so that if they got notice and they did nothing, use that as a way of cutting them out of a potential challenge to that will later. So there's really the before, the middle, and then at the end you look at them and say, well, you had your shot, I gave you notice, why didn't you show up when we had the hearings?
Okay. Now, Joe, there is a statute of limitations that you have in which to act to challenge a will, and you mentioned that is
Yeah, fundamentally it's 1 year from the time the will is accepted for probate. There are slight exceptions to that, but it usually has to do with if it's a beneficiary underage.
Okay.
So,
okay. All right. We've talked a lot. There's a lot of different types of issues that can arise. You guys have brought up some very excellent points. Talk about some of the common problems and pitfalls associated with these various ex parte probates. Either in the probate office or even in litigation. Tom. What's your thought about that?
Well, the most common ones that I've seen when you start down that road is not taking into account really where it could go, and really trying to take advantage of these things that Joe and I already talked about to try and cut it off initially by giving the proper notice, by doing what you can to make sure that anyone who's out there who might have a basis for challenging is really given that opportunity, either factually or legally. And with that, I have in mind this notion that there might be an underage beneficiary, there might be someone who we know is out there, but we can't find them. Maybe we're not sure if there's someone out there, and so we end up wanting to publish to the world that they're out there. But then doing what you can to get them served, and if you can't, use the full-blown process available and get a guardian ad litem appointed. Get someone who's going to stand before the court and take the shoes of, look at this through the eyes of the person who you might not otherwise be able to find. And if we're going to fight about it at all, if there's going to be litigation about this or a question later, let's do it now, because I don't want a 5-year-old potential beneficiary to turn 18 and come back later and say, well, I didn't know about it, or I was only 5, so I want to challenge it now. I want finality, and that's one way to do it really well.
Now, Joe, in the case of the ex parte, probate office, undertakings, what are the kind of problems that we run into there that causes those to not go smoothly?
well, little things like we got to bring the original will there. Copy's not going to do. That's a separate problem. You have to bring a death certificate. The will itself has to have what Tom mentioned it to be a self-proving affidavit. If you don't have that, then you have to have a couple of witness depositions. You bring them along.
Okay.
Things like that. So you got to have all your ducks in a row.
Okay. I'm going to run through real quickly some of the common claims that can arise in the course of an estate, just to kind of, maybe dispel some misconceptions the public may have about certain things they think people have a right to. So, Joe, mom and dad write a will, and they, when the last one dies, they don't leave anything to their children.
Yeah, I mean, parents don't have to leave anything to their children, although if there's a child born after the will is made, the child is not cut out. The child gets some share of the estate. It could be all of the estate. And there are some protections for young children, even if they're left nothing in the will. If they're under age 18, there are protections with a dollar value that can be asserted. But yeah, no, even if you behave well as a child, mom and dad can cut you out. So
what if mom and dad leave something, but you don't think it's enough? What can you do about that?
Not much you can do about that, Richard.
Okay.
You can have a good cry and then move on with your life.
There you go. Now, Tom, what about a spouse? Let's say that can a spouse make a claim against an estate because their deceased spouse didn't leave them enough?
And that's a circumstance where the legislature has stepped in and said, yes, they can. We have something called, you might have heard of something, an elective share claim, where you elect against the will. You say, well, this is what he was going to leave me, or she was going to leave me. I don't like that, so I'm going to elect to take the statutory defined amount And it's a pretty complicated definition as to how it's calculated. But yes, a spouse who's cut out does have that right to make that claim. And it's very precisely, I think would probably be the wrong word, but it's certainly defined in depth.
And the other thing would be, let's just say that the spouse is not left anything.
The omitted spouse situation is actually a separate potential claim for that. And what we see there by the definition of the omitted spouse is it has to be a situation where a will existed prior to a marriage. And so, and there's other exceptions as well, which it has to be clear that there was an intentionality, I guess, by the testator there to not purposefully have left that person out. And so we've stepped in and made sure that under those circumstances that the individual be protected.
Well, we're nearing the end of our time here, so very briefly, fellas, some final thoughts, advice for folks who are undertaking to admit a will to probate or who are facing will contests. Anything you can share with our viewers?
I think it's always a good idea to see a lawyer about a will. I do. I mean, a lot of wills work out when you don't see a lawyer, but it's a little bit more of a roll of the dice.
The old adage, penny wise, pound foolish. I agree. As a litigator, that's virtually every case that's walked through my door is someone where there hadn't been enough prior planning in some way, shape, or form, and that's usually what leads to them having to make the tough decision of whether or not they want to fight about it, and unfortunately that often is cost prohibitive.
Well, Joe and Tom, thank you so much for taking the time to visit with us today, share all this great information, and for the great public service that you have done for the citizens of Northern Virginia and for the Probate Nation. Thanks again.
Okay. Thank you.
Thanks. You're very welcome. You would think it would be easy to get started on your probate journey with a quick trip to the local probate office with Mom's will in hand. And when that is completed, off you go on your probate train ride. Yet, as we learned in earlier programs and further today, there are so many challenges that can arise to that will you want to admit to probate, and often those challenges are costly to resolve and very time-consuming. The good news is that there are steps that can be taken at the time the will is prepared or executed to avoid some of these challenges. But if those steps are not taken, you may face protracted litigation to sort out how Mom's estate is ultimately distributed. If you encounter challenges to the will you seek to admit to probate, I encourage you to reach out to an attorney who is experienced in litigating fiduciary matters to get guidance early on how to resolve the same before litigation is filed. And if litigation ensues, then to provide representation in that litigation. This brings us to the conclusion of our show today on Is This a Will? I hope it was informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.